This is Rick Hackett staff. We are recording. You can begin.
Thanks, Rick. This is Acting Chair Sam Libby, Commissioner Sam Libby, calling to order today's Planning Commission meeting for November 10th, 2020. This is a Planning Commission discussion on docket DC-19-0002, amendments related to Article 12 of the Land Use Code. I'll be starting off with a roll call before moving on to the next items of the current commissioners. So as a roll call, Melanie Neske.
Here.
Sam Libby here. Lucian Gargano.
Here.
Mark Bloomfield.
Here.
Sam Fitch.
Here.
Gavin McMillan.
Here.
And Dan Hilton.
Here.
And Todd Quigley.
Here.
All right, thank you all. We're going to be starting today. I'll start a couple comments for the public that's attending. There will be no public comment today. That was yesterday's session. Today is for discussion and questions with staff and a potential recommendation to the county commissioners. We're going to start with some feedback from staff on the public comments and questions yesterday, followed by questions from the commissioners and discussion after that. I just want to remind everybody also that written comments are accepted at any time on this topic to Community Permitting and Planning and can be submitted through the website that we provided in the past. And with that, unless there are any other topics from staff, we'll move into the responses from yesterday's session.
Good afternoon, Commissioners. Kim Sanchez, Deputy Director, Community Planning and Permitting. I will kick us off into responding to some of the things that we heard at public comment yesterday. So first off, there were several comments related to climate and concerns that we weren't doing enough to address climate impacts through these regulations. So this set of regulations is, again, a reminder, are really structured to update our 2017 set of regulations based off of the new or clarified authorities that were granted to us by Senate Bill 181. Air emissions is one of those stated areas of authorities. However, climate is not specifically. So we're using, looking at air emissions as essentially a proxy at getting at some of these climate issues. And that's one effort through these set of regulations. I will, however, also mention what I said yesterday about the county has this overarching multi-pronged approach to address oil and gas impacts. And as part of that, we're involved in litigation over climate, specifically the Suncor case, which the county attorneys that are with us in this public meeting today could speak to in more detail if you have questions. So there's climate litigation as part of our multi-pronged approach, and we also have many of the sustainability programs that I tried to highlight yesterday in the slides, both for businesses and homeowners in unincorporated, in all of Boulder County, not just unincorporated lands. So we think that many of those will go a long way to address some of the things that people raised as concerns related to climate. It's certainly at a top priority for the county's overall initiatives. The second thing that I wanted to address was we heard a lot from people about the proposed setback that is in the regulations. What staff has proposed is a 2,000-foot setback from dwellings and associated residential uses and from child care centers. And this is designed to be consistent with the setback that the COGCC, the Colorado Oil and Gas Conservation Commission, is also looking to adopt in their mission change rulemaking set of rules. So their process is not complete yet, so they don't have final rules adopted yet. It's looking like the effective date for those rules will likely be January 15th as the latest amended date. But we've argued at the COGCC during the rulemaking for that 2,000-foot setback based off of largely the CDPHE study that was published in 2017, as well as other nuisance impacts that we know are felt at that distance. So we recognize people want a bigger setback. We've landed on one that's consistent with the state. But we do want to recognize that the regulations that are in front of you also allow for us to dictate specific locations for an oil and gas facility or operations based off of the site specifics on that particular parcel. So there could be circumstances that lead to more than 2,000 feet away if we find that it's in conflict with other of the standards that are listed in our criteria. So could be more than 2,000 if the specific circumstances warrant that situation. The third thing that I wanted to respond to is there was some concern over the language in our review standards about avoiding, minimizing, and mitigating, as well as the qualifier of sufficiently. So I wanted to explain that the avoid, minimize, mitigate language comes straight from the language in Senate Bill 181. The reason we put in the qualifier of sufficiently analyzing if things have been addressed is because there is some judgment that's going to need to be applied as we evaluate each of these proposals as they come through the door. So, you know, there really is no scenario where there's not going to be any impacts to, you know, to the county, because just like any land use, that the process is set up to look at the impacts and to the extent that we can avoid them and then minimize and mitigate. But we do think that we have a robust set of conditions of approval that if we get to the point of being able to support a proposal, those would sufficiently protect the standards that we have in place. Also want to recognize that the public would be able to weigh in on whether or not they agree with, you know, staff's assessment of that evaluation. So that's how this process is set up, so that people can provide their input, as well as having staff, planning commission, potentially POSAC, and the Board of County Commissioners evaluate how each of those standards is met. Somebody mentioned that they wanted to confirm or be sure that all phases of development are addressed, and I did want to confirm that these regulations do allow us to regulate all phases of an oil and gas development, whether that's pre-production, production, or the inspection phases that would take place after one is already on the ground. The next thing, City of Boulder had provided some input about how they could be incorporated into our review process. I did want to call out that in the process, which is 12,800K, we have a referral to other agencies and departments. So the way that we've structured this is that we would provide a referral to the City of Boulder. They would have 75 days to provide their input to us. And any referral agency could request additional time if that were necessary. So if they wanted to then take this referral to any of their own boards or commissions, they could do so within that 75 days, or let us know if they needed more time in order to provide that referral input to us. But we wouldn't necessarily be writing City of Boulder's regulatory bodies into our set of regulations, but they could do that on their own as part of the referral process, if that's how they wanted to proceed. And we're happy to have further discussions with the City of Boulder about that. Related to the timing of Senate Bill 181 and COGCC's rules to implement Senate Bill 181 at the state level, you know, originally we tried to have those processes the state's process and our process be distinct, because we've been participating in that. We know many of the public are. The timeline has just extended due to just the volume of rules that are being analyzed and completely overhauled at the COGCC. So we do think that the process to update our regulations is independent of their process to update their regulations. There may be some interplays between the rules, and we can always revisit those points of contact if needed later, but we're comfortable moving forward with our own set of regulations despite the COGCC's rules not yet being adopted. What gave us our authorities are the bill itself. So Senate Bill 181 is what provided the clarification and granting of new authorities to the county and local governments. And we have what we need to move forward to update that in our Article 12 set of regulations. We did receive some comments related to wildlife and some recommendations there. We'd like to take a closer look at those comments that came in, as well as all of the comments that came in sort of late breaking yesterday. Just haven't had adequate time to really analyze those, but the wildlife ones in particular, we want to take a closer look at to see if there are changes that we could incorporate into the a next draft of the regulations if we do end up modifying it. I think the last thing was a response to some of the comments that we received from industry, and Kate Burke is going to respond to those.
Yeah, specifically, the industry representative, Mr. Seastrom, I think, talked about confidentiality issues. And they had also supplied, two different industry groups supplied some red line comments. And those points are well taken. We're going to take a look at the confidentiality issues and how those work timing wise, and then also we have to look at our obligations under the Colorado Open Records Act, as well as what we called common law confidentiality principles. So we will be taking a look at that and considering those comments. I think those are the primary ones I wanted to respond to now, unless you have questions.
Is that all the staff comments, Kim?
I think that should do it, and we're happy to entertain any questions. I will remind you that we do have technical experts on hand if you had questions about any of the specific air quality provisions or other.
Yep. Yeah, just to note on how I'd like to run the next set of comments. I think first, if the commissioners have any questions on air quality and public health elements of any of the regulations proposed here, I'm happy to take those first, as we have those specialists here right now. And then I think we're going to go through each subsection of Article 12, and I think we'll end up mixing questions and comments together probably, realistically. But if you have general comments, let's hold those till the end for discussion. We'll kind of go through each one. We can all share our questions, get feedback, and move on to the next one. So with that, are there any comments or questions, or rather questions about air quality or public health components here, any of the testing, monitoring, or those areas before we get into the actual pieces?
Sam, this is Commissioner Fitch. This is a comment about air quality, but it also applies to a number of the other impacts on health, safety, welfare, wildlife. And that is, the question is really about, are we being sure to include language that refers to cumulative impacts rather than simply looking at the marginal addition of any one particular applications. So this has come up in land use planning and water pollution, I think more than anything else. But again, it seems to me in this case, particularly for existing wells, for example, there's sort of a status quo, but any impacts from the new proposals coming in. It makes a big difference, the scale of those things, as they're added to the existing background already impacted by existing operations. So I think we need to look at those sections where we are talking about air quality, impacts on water, impacts on health, that we are talking about the cumulative impacts of a particular proposal, taking into account the existing backgrounds. I think the language is written that way, but it might avoid some problems later on if we can clarify that to make sure that's the standard.
I'm happy to respond to that. 12-1000 certainly does point to cumulative impacts and that being part of our analysis. So in the second paragraph of 12-1000, which are the standards, it does say a proposal meets the standards if it will, with respect to each subject area below, either avoid adverse impacts to public health, safety, and welfare, the environment, and wildlife resources, or through imposition of conditions of approval sufficiently minimize and mitigate unavoidable impacts. Oh, I think I skipped the line that it's actually in. Hold on. I am sorry, I thought I had it. Here we go. It's the very first sentence of that second paragraph. The board will determine whether the proposed oil and gas facility or operation individually and in light of the cumulative impacts of surrounding land uses complies with these special review standards. So we've incorporated it there. If the board would like to see further clarification, that's certainly something we could look into. It's definitely something that we have testified to at the state level to look at cumulative impacts, where maybe the regional review of these kinds of things is more set up for a critical look at how cumulative impacts can be evaluated.
This is Commissioner Bloomfield. I think the question that brings up for me, Kim, is, is that something that staff is going to have as one of their boxes to check, looking at because obviously we as commissioners are not going to be able to look at what the cumulative, for new application, we're not going to be able to look at what other wells might be impacting this. So is that something that staff is going to have as one of their check boxes to make sure that they're, really looking at it comprehensively?
I do think so. So there are a number of pieces of information that we've asked for as part of an application, including other wells within, certain proximities, other surrounding land uses. There are things that lend to our overall analysis of how one proposal is looked at both individually and in light of all surrounding land uses, including other oil and gas facilities in an area, because we know that sometimes those impacts can compound if you're already near an existing oil and gas development and a new one is coming in. So I do think that that's our intent, is to have that be, it's really part of a general planning practice to consider cumulative impacts, and certainly one that we'd like to carry over in the analysis of oil and gas operations and facilities.
Thanks.
Any other questions on the air quality monitoring or public health components right now? Okay, so I think with that, if you're all good with that, we'll move into kind of running through our questions and comments about each section as we go through. We can take as long as we need for each of these. There's no rush, and you can always come back later on. It's not the only chance. So I've prepared some questions for a few of these, but I'll give you guys all a chance to speak first when we get to them, okay? So let's move on to 12-100, which is the purpose. This is mostly prefatory Are there any questions or comments here? And then same for 12-200, the authority. I don't know these statutes specifically, but for staff, I assume those are the relevant pieces. Is there any reason to refer to SB 19-181 here, or is that not relevant?
SB 19-181 is the way the bill is titled and dealt with as it works through the State House. Once it's enacted by the government, it actually contains amendments to several different statutory pieces, and those have now been added into the main set of statutes. So, for example, it made amendments to Title 29 and to Title 34, and so it doesn't have an individual role to play anymore at this point. So the right statutes are all listed out there.
Okay, thanks. Any questions on 12-300, the effective date and survival clause? Okay, moving on to the bigger sections. 12-400 is operator registration and renewal of registrations.
This is Commissioner Gargano. I think this was the section where we heard quite a bit about confidentiality.
Right.
I think as far as the questions go, my guess is it's more that staff probably needs to look into a couple things here about confidentiality, you know, when, and it's probably going to be a case-by-case basis, but I guess just knowing where we write in the confidentiality stuff versus where we set those, what'll be confidential sort of as we start talking to applicants. And then the public was asking a lot of questions about, you know, when and how it'll be visible to them. But it sounds like that's mostly has to be case by case, but I guess I just want to clarify that.
I think, can I speak to that?
Yes, please.
Yeah, so I think it's a little bit of both. I think we need to look at procedurally, when do the confidentiality discussions happen before the industry's recommendation was they happen before anything is submitted. So we just need to look if that's a good idea and if the regs support that or if they need to change. As far as what exactly constitutes confidential information, I think there are probably general discussions to have up front, and then there will be discussions on a case-by-case basis, because there's numerous sources of law that say whether something is or is not confidential. And so some of those things we can hammer out in a general way ahead of time, and we'll just need to sit down and look at that and have some conversations. But I would say chances are we will not be writing the very details of that into the regs. It'll be something that we'll handle on a kind of almost like a policy document or as practice for staff. But we won't probably change the regs a whole lot as far as those particular details.
Thank you.
I have a question about procedure for existing wells and how they come in. Like what happens if in this, I think you have 60 days from the regs to come in and register? Two questions. What if they don't come in? And two, what happens if they can't check one of the boxes as part of their registration? How do things move from there if that were to happen? Like they can't provide something as an example.
Yeah, so I think the 60 days being, or one of the commenters said 60 days was too short. And that is something we could look at again. I think that was our best guess. Our intention there is to bring all the current operators into how we want to see things moving forward. But if 60 days is impossible for them, I think we'd probably be willing to listen to that and make some modifications. I think that, there's always the possibility that the director can determine that maybe some extra time is needed, that kind of thing. There were also some comments from, I believe, industry folks who pointed out specific pieces of the registration that maybe they questioned their applicability for current existing facilities. So that too is something we could take a look at. So I think that where I'm trying to get to is that we want to get the registration done in a timely way. If an operator is, refuses or utterly fails after we've worked with them to complete the registration, then technically that could be a violation of the code. So we could look to those violation provisions at that point. I don't think that's where we would intend to get to.
Yeah, I'm sorry to ask an open-ended hypothetical question, but so basically though, what would kick them down into the enforcement part of this section of the code ultimately? It could.
So
it is a requirement. Yeah, go ahead.
I think what I would say is that the registration, we plan on doing some outreach for that too. So we'll reach out to the operators. We already had a previous registration section in our 2017 regulations. So we have a number of operators that have already sent us the minimal registration requirements that were required in 2017. This is certainly a beefed up section. So we do plan on doing some outreach to them so we can, know who is on record in the county as being an operator. That's to our interest. Ultimately, I think what it comes down to is that an operator would not be able to proceed with an application if they weren't registered. So if we don't get, the folks registered through our outreach programs or through, enforcement, I guess if we were to go that way, I don't know. I hadn't kind of envisioned that path, although I think it's certainly possible. Then we could, we just ultimately would not process an application unless we have a registration from an operator.
Very helpful. Thank you.
This is Commissioner Libby. On that topic of the previous, I guess, code and the registration list, I'm interested in whether the intent of the registration is to be public. Like, is that list to be made public of registered companies? And would the application process be public as well? Like, company X has applied for registration in the county, or would that be private?
Well, all of our information is public. So any records about registration could be viewed by an interested member of the public. I don't know that we've thought of publishing that list. It's more for our understanding of what operators we have in the county and kind of what their records and all of the other things that we've asked of them through the registration materials are. So we have that information going forward, but a member of the public could certainly look at that information if they wanted to.
Okay.
I'll just chime in, except this is where the confidentiality piece would come in. So the fact that a company has registered and probably many pieces of their registration would be public, but there may be some pieces that aren't under those confidentiality rules.
And my other question was about item D in this section. So that has to do with the annual renewal. Just to clarify, I guess, what's meant by the cycle there. So it says registration must be updated and renewed annually by July 31st. Let's say my registration was approved on August 1st. Do I have basically 2 years to renew, or I have to renew before the next July 31st? I think some specificity there would be helpful.
I think we're looking at it as sort of just a checkup on ourselves to make sure that we have up-to-date information on each operator at a particular time each year.
Okay, the burden is not on them, or it is on them to renew their information by the 31st?
It is on them, but I see it as, we benefit from having this information as well. So I think we could check in with people to say, like, do you have any updates to the information that you submitted? It will be due by July 31st.
Okay. Any other questions on the registration section, 12400? Let's move on to pre-existing facilities in 12500. I had a question to start this, Commissioner Libby. Do you guys have a rough idea of how many existing facilities exist right now in the county?
A couple hundred.
Okay, and what's the level of detail or maturity of information you have about those sites? I'm sure it varies, but do you have any information about previous applications, and would we be referring to that?
Yeah, so we had regulations that were in place since 1994. So many of the wells went through what was our previous review process, which was called a development plan review for oil and gas. At that time, when many of those were approved, we were in a totally different legal landscape insofar as what our local government authority over those were. And there were many areas where we were preempted from regulating the things that this set of regulations looks at. So I'd say that the information in even for the wells that we do have previous approvals and application information for, it's really minimal, because essentially we were only looking at kind of access and maybe some wildlife issues related to those.
I'll also add that many of those wells were actually drilled in the 80s. So, but even before the DPR process was in place.
Yeah, I'm referring to the ones that went through the DPR process. Those application materials are not particularly substantive. And then there's that whole subset that Kate's referring to that were pre-1994, where we likely don't have any information on those, maybe some permit information, if anything.
My next question was about the emergency response plan in 12500F. So I assume I didn't compare, but it's basically all the same sub-items in that to what's in 12900, same style of emergency response plan as what's later in the document. I guess I'm a little concerned, or is like the question is, would you expect all of those several hundred existing facilities to develop that full emergency response plan, and then staff would need to review and approve all of those before the registrations would become active? Is that right?
It's separate from registration, but it's a requirement of a pre-existing facility. So I think that is one of the, that was certainly one of the issues that industry raised, that we would like to consider further, whether the level of detail that we've asked for in this emergency response plan for existing wells is the right amount of information, or whether there are some things that we can leave out of that. I mean, we're talking about very different scales of development from the type, we want a very robust emergency plan for new facilities, so we can know how somebody is going to respond to any emergency that were to occur at that facility. But as explained yesterday, that what we'd likely see for a new facility is a very large multi-well pad. Given that the pads that are pre-existing are really primarily 2 wells, I think we can have a conversation with industry about what the appropriate level of emergency response plan would be for those, so that we still feel comfortable that we know how they would respond if there were to be an emergency on some of those producing wells, but maybe it doesn't rise to the same level of detail that's required for a new facility.
Great.
Also,
Yeah.
one comment I was going to make about the emergency response plans, I believe if you look through the ingredients of the plan, many of those could be general from an operator and applicable to all of their facilities, and then some of them are going to be more site specific. So what I'm envisioning is that if an operator had 10 different sites, they would have 10 different plans, but some large portion of those plans would be the same, if that makes sense.
Yeah, it seems to me that something more than what you have now, which is in some cases nothing for those current sites, but maybe less than the full plan, might be right. And that plays into the 60-day timeline too. So it sounds good to revisit that. Thank you.
This is Commissioner Bloomfield. As far as that emergency plan, if that's not tied to the registration, is there, I don't see anything, at least at a first glance, that gives a time frame for the requirement for that being filed.
You're right. There is nothing specified. You know, some of this will be outreach with operators, but we could certainly add provisions in if you felt they were necessary.
Yeah, it's a good point. The registration is 60 days, but not the plan submission. Is that right?
Yeah.
Yeah, I think, you know, maybe in your discussions with industry, you know, figuring out what a reasonable time frame is, but having something in there so that we can have a checkup to make sure that, you know, that the plan is actually being.
Yeah. I might suggest doing it on the 31st of July as well. Maybe just that's kind of the annual, get all the pre-existing facilities checked in on, and get people registered.
So you mean for the first time?
Yeah.
I like that idea.
I don't know. Just gives you one date to track as opposed to multiple.
Yeah, I think it's a good coordination. I mean, if they're going to be submitting registration information and they also need to submit information on emergency response for pre-existing, it seems like they could do that on the same time frame.
This is Commissioner Libby. I want to ask about noise. This is the first time noise is mentioned so far. If you just speak to, I know that's a blank right now because you're waiting for the results of the testing that's underway. Can you just describe the sequence of when those results will come in, if they'll be before the board when they review this, and how that works? And I have a follow-up question after that.
Yeah, I'll say a little bit about that. And I do want to clarify, I would not characterize, I don't know that you did, Commissioner Libby, but people have characterized what we've done as a noise study. It wasn't that in-depth. We've taken 24-hour noise sampling at several locations in the greater Wattenberg area, either near where there are multiple residences or near where some the Crestone Peak Resources Plan had proposed certain sites. Just wherever we thought was a good place to sample, we took 24-hour samples. So that's not a very in-depth study. We actually did just receive the raw results of those a handful of days ago, and we're in the process of looking through that and determining how to use that base data to come up with the noise maximums that we're looking for. There's a fair amount of variation. You know, of course, we had day and night time, so we need to spend a little time looking through those. But the idea was we didn't want to, there's a couple approaches to regulating noise. One is, this is your noise max, you can't be louder than this. The other one is, you can only be louder than the existing noise plus X number of decibels on top of that. We didn't want to do either of those without knowing how noisy or not noisy it already is out there. We thought we could wind up with something unreasonable. So it's going to take us a little while to figure out how to interpret the rather varied data we got and what to do with it. But yes, it will be done before it goes to the board, and hopefully sooner than that. Of course, you'll want to take a look at that too, or have some input.
Yeah, just one comment and question. You know, just as a comment, also the county does have a noise ordinance countywide that does provide a baseline of residential noise that would cover these areas as well, unless that's not correct, but that's my understanding. And the question I had was, since we're in the section about pre-existing facilities, assuming that many of these facilities will be much closer to residential areas than what would be potentially allowed under the current application, the proposed application process, is there any plan to have a different standard for pre-existing, or it would be the same noise decibel numbers in both sections of the regs?
We had not talked about a different standard. You know, we don't get noise complaints from our existing facilities, and the noisy parts of oil and gas development are generally the early parts, not the long-term production. So we're not tremendously concerned today about noise at pre-existing facilities. We wanted to make it consistent and predictable across the way, actually. So we had not talked about doing a differential standard. It might be tough because often if there were to be new development, it may be right next to existing development. So that might be tough to implement anyways.
I think if we have a not to exceed standard, then the existing wells would certainly comply with that not to exceed.
Yep, great, thank you.
Commissioner Bloomfield, I know there's some public comment that the county is noisier than it has been because of some air travel and airport usage and whatnot. And so using an existing baseline was not a good starting point, I guess. Have y'all looked at any complaints in that regard and like tried to figure out, like, I mean, I don't know if this was just one person making that complaint. I mean, has there been a number of complaints about airport usage and the noise associated with it? And does that in fact impact the area that we're talking about? I'm curious what your thoughts are.
I can't speak to whether there have been complaints over time about airport noise, but that's kind of what I mean by saying we didn't do what I would call a noise study, which in my mind would look much more in depth at all of the different noise sources and how they do and don't come together. You know, what we have is a 24-hour sample at a different site. So presumably, if there's a lot of air traffic, it would show up in there as, you know, certain spikes during that 24 hours. The kind of data we have is not granular enough to be able to like weed out certain sources. I don't, and then I guess, I don't know, Kim, does the community planning permitting get airport noise complaints? Is that a thing?
I haven't experienced any of those in my time here. Dale Case is on this in this meeting as well. I'm not sure if he has, but I think that the challenge of that is trying to extract out the airport noise or airplane noise from you know, from the general background ambient noise. So I do recognize that being, you know, a factor, but it's also, I mean, I'm not the person that's doing the noise studies for us. That's why we hired outside consulting, but it seems difficult to try to separate that. But possibly it could be done, I'm not sure.
And we also can't look to the oil and gas industry to make it quieter than it already is either. So it's just, we're not quite sure where to go with those comments, although we heard them and we'll take them, you know, to give them consideration because they matter to the public, so.
Yeah, it gets into that sort of cumulative question, even if it's different issues, right? So, thanks.
This is Commissioner Nuski. I have one question on this topic for transportation. I have another for air quality, and I'm wondering if I could ask that before our expert needs to take off. And I know we got a public comment this morning, an email to us, and it was talking a little bit about flaring and venting of natural gas. And I'm wondering if you could speak to the air quality considerations for flaring and venting, and if there's a threshold for that.
So if we could come back to that, I'll let Cindy Copeland and some of the other public health folks take a shot at that, and then I'll see if I can get Elizabeth Pranos, who was on, but we didn't think we had any air quality questions for her, so we released her. See if I can get her back on this meeting. But Cindy, I don't know if you want to take a shot at, or Colin, at addressing that.
Yeah, I just want to make sure I understand. So you're wondering if there are release thresholds for flaring or venting?
Yeah, and is that something that just is an aspect of the oil and gas, or is that something that can be done in a different way that's contained, or is there a threshold that's considered acceptable? I don't know too much about the flaring and venting, so I was wondering if you happen to.
Yeah, so unfortunately with flaring and venting, it's not something that can be easily quantified, meaning that it would be difficult to come up with a threshold because it's hard to measure exactly what the emissions are. And so just because it's, you know, a lot of small, you know, sources and it's diversified and that kind of equipment is, I think, fairly difficult. But there are usually what's called a destruction efficiency, like for a flare. And so a flare would usually, when it's manufactured, they could expect like a 98% destruction efficiency for the flare. That doesn't mean that there are no emissions or only, you know, the 2% emissions. And usually it's not, once a flare is installed, it's not quite, you know, 98% efficient. But yeah, so flaring and venting, you know, the emissions are, it's a really big problem and something that people have been trying to deal with for a long time. There are options for flareless completion. So that is one option that can be pursued with you know, installing that at newer facilities. That would be more likely. It's also called green completion. So those are some options for flaring. And venting, one thing, I mean, the state and the Air Quality Control Commission regulations, they've done a lot to address venting so far. There's a lot more that could be done, but that happens from a number of different sources. And so tank controls have been a big part of the AQCC regulations to date. And part of that is to reduce the amount of venting from the tanks. Did that answer?
It did, yes. It spurred another question because the same comment made the same public comment talked about tankless operations. Is that something that is like an industry standard, or is that something that is typical? Like, could you require that for a new operation, a tankless operation?
Yeah, and I'm not sure if Kim or Kate want to answer that more broadly, but just from the air quality side, I mean, I know that that's happening more and more in the Front Range, that the newer facilities are tankless. Or what we've heard more recently is that they've said that they're not actually tankless because they do have to have a few tanks on site, but they call them tank light, meaning they don't have as many tanks as they normally would have, but they have fewer tanks. And so that does reduce emissions. You do see, you know, cases where there's more pipelines, and so then you need to look at emissions from that, the transmission segment, because you would increase the pipelines and increase emission sources in that respect.
And it is our intention in the regs to have a tankless requirement as a potential condition of approval. That's one of those technical things that sometimes we have to double check ourselves to see if we've used the right language in the right place. So we can do that.
And I think it is in the provisions under 1100D. So the 2017 regulations, if I recall correctly, actually used the term tankless, but in the update, Elizabeth kind of upgraded our language to have it read with the exhaustive list of emission controls and you know, technical provisions that are listed in that particular section. But it's my understanding that the tankless facility is one of those requirements under the conditions of approval. And if we're able to get her back, we can certainly circle back to that question.
There's also a prohibition of routine flaring and venting in that section as well.
Right, and the green completions that Cindy Copeland was speaking to is incorporated in there as well.
And I'll also point out that COGCC is in the process of implementing their own new venting and flaring rule that'll govern all of that too and create more limitations.
Thank you. And my other question was on the section we were just reviewing. It would be F4, and it has to do with the transportation routes for an emergency response. There was a public comment yesterday that was speaking to the ingress and egress points And I was just wondering, will the project-specific emergency response plans take into account the neighboring communities and that sort of thing? Is that sort of covered in that specific plan, or are the emergency plans just for the facility itself and not the neighboring community?
Well, the plan has evacuation route components. It also has local resident outreach components for, educating the surrounding neighborhoods on emergency response. And then another comment that I think was related to the one you're talking about, and then also I saw another comment in some of the red lines having to do with, what if there's only one way out? Because we're asking for two ways out. Or I know there are stories about where the plant itself is situated in such a way that it could potentially block the egress from the, so those are all things for new facilities. Those are all things that would be handled through the review process, and we'd be preventing that kind of egress blockage problems. For existing facilities, of course, we don't have as much power to do that, but these are things we'd be looking at. If, for example, there was a question, somebody raised a question, what if there's an existing facility and there's only one way out as it is? And that's a good question. We'd have to look at, is there a way that we can have any effect on that, even though it's an existing facility?
Thank you.
Any other questions on 12,500 about pre-existing facilities?
I have a question. This is Commissioner Hilton on C2B, equipment assisted inspection for emissions or releases, including use of best available technology such as infrared cameras at least every 30 days. So I guess a couple questions about this. Is the operator, is it up to them to determine what they're inspecting, or does the term emissions or releases, is that defined somewhere to include a certain type of inspection, for example, methane?
Kate, you're on mute.
I'm hoping that maybe our public health folks can chime in and speak to their inspections of existing facilities now, and that might provide an example of what we're trying to mimic in regulation form. So right now we have a voluntary inspection program at existing facilities, and this is intended to codify that same program.
Okay, I guess I'm just wondering if this could be tighter. It seems like we're not specifying, at least from what I can tell, we're not specifying what we're inspecting for or what they should be inspecting for. And then best available technology, is that, do we feel like that's a particularly broad statement, or how do we have any ways to disseminate what we expect is best available technology?
Kim, would you like me to respond there? Okay. So I'm Colin. I manage the oil and gas inspection program, the voluntary program that collected data and conducted inspections through most of 2019 from 2014. That program did have a standard operating procedure that involved a audio-visual inspection, as well as infrared camera inspection. Basically, it was a leak detection program, and the inspector would report any releases that he found at the time to the operator, who would then respond by checking and seeing whether that was a permitted release, or whether that release was due to a malfunction of equipment that needed to be repaired. And there was some follow-up done by the inspector to ascertain whether it was a permitted release or not, and therefore defined it as a leak. So that was the nature of the program. I think some of the lack of specificity in the language is to allow the technology to evolve. Because, you know, infrared camera is still good for identifying leaks. At the time, it was the best technology for identifying leaks at individual sites. We are trying to keep it, I think, open to allow technology and detection is evolving very quickly, and I think there's trying to create some room for that there.
And if I could add just one quick thing, I'm sorry, I didn't introduce myself in the beginning. I'm Cindy Copeland. I'm the Air and Climate Policy Analyst for Boulder County Public Health. And just a quick thing about the infrared camera is that it doesn't differentiate, as Colin was saying, it identifies the leaks. And so it can't tell you what's coming out. It's just, you know, the camera you can see the visual that there are emissions coming out, which, you know, most of that is methane, and so it's heat related is what you're seeing in the camera.
It also can't quantify what is coming out.
Yeah.
As Cindy was saying earlier, these releases are difficult to quantify, even with our best technology.
I think the idea is to identify if something is leaking so that we can work with the operator to fix that.
Okay, and in this provision, they would be identifying if something was leaking. This is an inspection that they are performing, not a part of a county program that we're going on site or doing any kind of spot inspection.
Correct.
So they're inspecting and then reporting, and then are obligated to report back to us.
Yes, in that particular set of provisions, in 12500C, the operator is inspecting the facilities and reporting back.
Okay, thank you.
Maybe this is Commissioner McMillan. I wonder if just adding that sharing those results, I mean, do you all anticipate every 30 days getting a trove of information from operators indicating stuff like this? And if so, I wonder if, you know, reporting those results should be part of the requirement.
So I think that's the next provision. So C3 notes that operators will report the date, methodology, subject, and results of all inspections to the county monthly.
That's exactly what I would have said. I'm sorry about that.
No, the logic follows. It's good that we're on the same page.
Okay.
And then I guess to follow on with that, the methodology, if they were to report a methodology that we felt was dated, outdated, and it wasn't best available, we have some mechanism to obligate them to come up to best available.
That's correct. I think this provision is enough to have that conversation with them. Yeah.
Okay.
We good to move on? Okay, we're gonna move on to 12600, which is about well and pipeline abandonment or decommissioning.
I'm make a general comment here because this is one of the areas where the industry groups were pointing out that some of this gets into what they call the subservice or the downhole regulation, which is a COGCC matter, not a local government matter. And that's not, yeah, that's not untrue exactly. It's just that we have land use authority, and these activities have significant surface impacts. So for example, the COGCC governs plugging an old well, and they govern how the cement that they have to use to pour down the well hole and how deep it has to be and all the different layers of the plug and the technical ways in which that deep well bore is actually plugged. We're not going there at all. What we're talking about is surface impacts. which can be significant because these operations take enormous equipment. These workover rigs, or I'm not sure the proper name of them, but they're, you know, almost as big as a drilling rig itself. So that's our area of both concern and authority, is the surface impacts. And then as far as the pipelines and flow lines, they're subsurface, but they're 2 or 3 feet subsurface. They're not 5,000 feet subsurface. And they have direct impacts on surface activities such as agriculture or excavation of any kind for surface uses. So that's what this area is designed. We're not compelling operators to plug certain wells. We're not preventing them from plugging wells. We are approving their plan to do that, the timing with which they're going to do that, the duration that kind of thing, not the sort of cement they're putting down the borehole.
This Commissioner Bloomfield, does this section, it's kind of in between the existing and the new sections. Is this something that will actually apply to existing wells when they are decommissioned?
Yeah, it applies to any well or flow line from the day these rules are effective going forward, so existing or new.
So just some more background on that. Plugging and abandoning of wells was something that was just minimally addressed in our former set of regulations because it was an area that the COGCC regulated. So all we did under our former set of regulations was ask for surveyed coordinates of where that well is located on the ground, unless the surface owner doesn't, or we required the surveyed coordinates, and then we asked for a physical marker of where that is, unless the surface owner didn't want that because it was interfering with maybe an agricultural operation or something. Those were the only 2 things. What this allows us to do is also put some requirements around the timing of that. There are oftentimes, you know, they may have to take equipment in to plug and abandon that well, and there may be wildlife that we're concerned with, you know, nesting or whatever impacts the wildlife could feel from that activity. So we just want to be able to coordinate accordingly based off of anything that might be impacted in the area. For the lines, we didn't have anything that really addressed the county's preference on lines. So often the easiest thing for an operator to do is to just leave it in place, to, you know, tap out, plug the ends of it and leave it in the ground. Boulder County's preference is to have those lines removed, so we don't have the safety issues and, you know, potential issues that could arise from that. There may be situations though where removing the line would be so disruptive to that particular land, given the, you know, resources on it, if it was, you know, going through a stream channel or something like that, where we may want to reconsider, but we want to be able to have that oversight through our regulations to do that. We've also added in the ability to require specific revegetation and reclamation. So sometimes we haven't found the COGCC's requirements around reclamation of that disturbed land to be to our satisfaction or to the level that the county would like to see that. So we've added in our authority to regulate around that as well.
Thanks.
Commissioner McMillan, section D1B, what is a tracer? It says a tracer will be placed in any non-metal line.
I believe that is metal taping or wire or something that is perceivable by a metal detector, basically. Oftentimes, some of these lines are small and they're made out of like PVC or something like that. And so once they're in place and years go by, there's not a good record of where they are anymore. And so what we're looking for is to prevent that by, first of all, asking for the coordinates when they go in the first place, but then also asking for some sort of tracing I'm sure there's different methods that they can use, but add something in there so that we can find it later.
Thank you.
Moving on to 700, any objection? Okay. Section 12700 is geophysical exploration for oil and gas or seismic testing. What questions do we have? This is Commissioner Libby. I have a question about setbacks or lack of setbacks. I understand the setback for the actual proposed location for a drilling or well pad, but is there any limitation on the location of seismic testing within a parcel? I know you have to notify people 400 feet from the location of that, but there's nothing here that restricts you from doing that right at the edge of a property, as far as I can tell. Is there any comment about that?
I'm just looking through it. I believe there's a, Jasmine, isn't there a setback from buildings? Where is it? And it's not, it's like three, go ahead.
Yeah, I was gonna be like, I don't think it's like a hard setback. It's just there has to be certain types of monitoring that happens if the vibration monitoring will be located within a certain distance from a building. So if you look at it's C10, ground vibration monitoring will be required for any source points located within 400 feet of any structures. So there's a certain set of monitoring that's required, and then there's threshold values. So if the vibration reaches a certain threshold value, then it has to be stopped. So I think that's kind of how it's addressed.
And I
I think-
think, let me, go ahead.
Go ahead.
Kim. Okay, a little background on this. We did not have any seismic testing regulations before. This is brand new because 181 gave us the authority, specific authority over vibration, which is basically what seismic testing is. And there are concerns, there have been concerns, not in Boulder County, but in the world, about potential damage to, say, building foundations, water wells, those kinds of things from the vibration that's caused by the seismic testing. So what we're looking to do is to protect property from those vibrations. Seismic testing is a very short-term, ephemeral thing. So if you have a given property, or your house in particular, the trucks, they're going to drive these vibro-sized trucks through there. It's going to be done for you within, I don't know, an hour or something or less, because they're just driving past and doing their vibrating on the ground. So the indications of actual damage are unclear. We did research that we could and found complaints, but very few verified instances of serious damage. So we found some model regulations that other jurisdictions had used, and then we also ran this by our noise and acoustical engineering folks for help in putting this together. So that's where this came from, and the goal is to prevent the damage that seems most likely, which would be to structures. There's also some concern, of course, about like burrowing animals and that kind of thing. And then the second kind of damage that seemed likely is these trucks, given under particular circumstances, they may be driving across, for example, open fields. A lot of Eastern Boulder County is very rural. And so to get the information they need, they may want to drive across agricultural or otherwise preserved property. So those are the kinds of damages that we were trying to regulate around. So as far as these threshold values and the certain number of feet, unlike the public health setback information we talked about before, there are not studies to be working off of when we are depending on our consultants. So if you have specific questions about that, we could certainly pass it on to them. But maybe that background helps a little bit in thinking about this.
The only thing that I was going to add, which is similar to what Kate said, is that the seismic testing is really a temporary type of thing. And so it doesn't have the same sort of, the setback is really more for a permanent, a permanent fixture. So an oil and gas facility from a child care center, an oil and gas facility from a dwelling. Whereas this is really just temporary and passing through, and we'll be monitoring what the impacts are within 400 feet. So slight distinction, if that's helpful.
This Commissioner, just another question, Kate, I guess, of what you understand of how this is done. Would seismic testing normally take place around the site of a proposed well pad, or would it take place some distance away from that?
So we've had 2 proposals to do some seismic testing in the county, which is, my complete experience with it, neither of which actually occurred, but both of them were proposals to do seismic testing around and across a pretty large area. It's a very preliminary step where they're trying to, I believe, trying to figure out where the resource is, what the geology is like under there, and then they, I would assume, use that to inform where they want to put their pad. So it's pretty preliminary. So we'd be talking about, for example, in one case it was a, I don't know, 2 or 3 square mile area through which they wanted to run the testing. And so they might say, well, this is going to take us a month, but they're going to drive these trucks on kind of a transit pattern through this large area. And to get it all done might take 30 minutes, but 30 days. But from the perspective of anyone's spot, they pass through relatively quickly. It's just that they have to do this back and forth pattern. Does that answer your question?
Yeah, I'm just thinking of how realistic is it that they actually would be within 400 feet of a structure if the potential well pad could not be within 2,000 feet of a structure? It sounds like they cover a large area because the horizontal drilling can go to those areas.
Exactly,
Okay.
exactly. And again, in our oil and gas area, there aren't that many structures, but they can do this testing right down city roads, through neighborhoods and whatnot. We don't have a lot of that, but it could happen. So that's why we included all of it.
Thanks.
And we do have Elizabeth Pranos back on in the meeting if you want to redirect your question to her, Melanie, or anyone else. I think you're muted there.
Hi Elizabeth, thanks for coming back. My question had to do with flaring and venting of natural gas. And I was just trying to basically understand sort of the implications for that. Like if there's a threshold that's considered unsafe, if it's a part of the industry, or, where does the flaring and venting of natural gas, and how does that play into the air quality that we're trying to monitor and make sure that those aren't reaching any dangerous levels? Or I know there's the National Ambient Air Quality Standard. So how does the flaring and venting play into that? I don't have that much background knowledge on that.
Yeah, sure, Commissioner. I'm more than happy to answer that question. So I guess I'll start with the latter part of your question. So venting is basically just releasing uncombusted natural gas into the atmosphere. Uncombusted natural gas is primarily methane. It depends on the specific segment of the natural gas stream where the venting is occurring, just how much of the gas is methane and how much of the gas has other hydrocarbons, mostly volatile organic compounds. But in the production segment, which is mostly the types of facilities you would be likely to get in Boulder County, the gas will be mostly methane, which is a potent greenhouse gas, and then some volatile organic compounds that contribute to ground level ozone. ground level ozone is combined or is caused by oxides of nitrogen, which is another air pollutant, that combine with VOCs in the presence of sunlight, and they form ground level ozone, or what other people call smog. There are also some hazardous air pollutants that actually fall into the volatile organic compound category, but they are specifically listed in the Clean Air Act under Section 112 as hazardous air pollutants because of the toxicity of those pollutants. And so, for example, benzene is a hazardous air pollutant. So when operators vent natural gas from a production facility, it's mostly methane, some VOCs, and then a few of those VOCs may be some hazardous air pollutants like benzene. Flaring is the combustion of natural gas. So basically what happens when the operators flare gas is they send it to a device, a flare or a combustor that is certified to destroy the natural gas up to a certain percentage of efficiency. So in Colorado, most flares and combustors have to be have to have a destruction removal efficiency of 98%. That means that there's 2% of the natural gas stream that's just being released into the air. So a little bit of methane, but most of it's combusted. And the combustion causes a combination of CO2 emissions, as well as oxides of nitrogen, as well as some hazardous air pollutants and some particulate matter. So depending on which thing operators do, you sort of get a different suite of pollutants. So venting causes more methane to be put out into the atmosphere. Flaring, less methane, but you still have other air pollutants, NOx, PM, some hazardous air pollutants. So the national ambient air quality standards, they are only for criteria pollutants, and that includes ozone, as well as particulate matter. So, both venting and flaring essentially contribute to the air pollutants that contribute to the national ambient air quality standards, whether it's ozone pollution, that's the primary one we talk about, or particulate matter. And so for the most part, operators, there's not a ton of flaring, not a ton of venting that occurs, just due to a combination of federal requirements and then CDPHE requirements that prohibit venting in most instances. Your regulations actually go farther than either of those and prohibit venting other than in a safety circumstance or where necessary for safety. And there are some instances where basically an operator will need to vent because there's a problem, for example, with the pressure in the system. And so let's say they're normally capturing the gas and routing it to a pipeline. The gas processing plant goes down, potentially downstream, and they have to actually they're no longer able to send the gas through the pipeline. So they may vent in that circumstance. If it's something that they know is going to happen, then they can send that gas to a flare instead of just venting it. But there are some instances where in a safety circumstance, they may need to vent. Flaring is often used as a way to limit venting. So it's actually an option for controlling natural gas emissions. So for example, the state of Colorado has a number of air quality requirements where they require control of emissions from specific sources like storage tanks. One of the ways that an operator can comply with air pollution control division requirement is to actually send the gas to a flare or a combustor that meets the state requirements for the destruction removal efficiency. But in many instances, operators can also capture that gas rather than flaring it. So while it's an allowed way to control natural gas emissions, it's certainly not as preferable as capturing those emissions. And again, in your draft regulations, flaring is also prohibited other than in very limited circumstances. Does that answer your question?
You're on mute, Melanie.
No, I couldn't hear you for a second. Let me take these out and see if I can hear you now.
It did answer my question. Thank you. And just out of curiosity for the captured, is there a way that you can, is there a way for operators to capture that gas and send it to be processed, or is flaring basically the best industry standard they have to process that gas?
So there are ways for them, operators, to capture gas rather than flaring it. It does in some instances depend on certain technical aspects of the facility, the design of the facility. So for example, operators who, it's the best example. So for example, the most normal sort of flaring of associated gas would be flaring of gas that otherwise could be sent to a pipeline. So either there's a pipeline that the operator is able to send the gas to and they don't need to flare, or if there's not a pipeline, there are other alternatives that an operator could utilize, like that use the gas on site. So whether that's converting the gas to LNG or CNG, or using it to generate electricity, those are all options. There are sometimes some barriers to when those options are available on a case-by-case basis, but certainly in most instances, there are viable alternatives to flaring, and then it's just a question of, you know, in the individual instance, is it technically feasible for the operator to capture rather than flare?
Thank you.
And Elizabeth, while we have you here, I was hoping you might be able to speak to the green completion and tankless provisions that are incorporated in our regulations. Those came up as well. Thank you.
Sure. So green completion, so basically when operators are completing a well, pursuant to EPA regulations that have been on the books for a number of years, there is a mandate under the federal rules for operators to capture the gas at least from the point when it's technically feasible to operate a separator, which is called the separation flowback stage. There are, however, exceptions in the EPA rule where, based on technical infeasibility, for example, if there's not a pipeline there, or economic infeasibility, the operator, pursuant to the EPA regs, is allowed to combust rather than capture that gas. In green completions are another term that's used to basically explain or used to call to, well, it's a different term for a reduced emission completion, which is the term that EPA uses. I thought we actually went with reduced emission completion rather than green completion in our regs, but I'm looking to see now.
Yeah, no, that's right, Elizabeth.
Okay, yeah.
And one of the specific, I'm sorry to interrupt you. One of the specific questions that came up was, we used to use the phrase tankless, you know, that we had a requirement for tankless facilities, but I think we've achieved that same thing, but using other language. Is that correct?
Right, so your regulations require there to be a pipeline before the operator conducts completion. So that is basically accomplishes the same goal. Okay. So tankless facilities is not really a technical term. It's a term that folks use to describe when an operator builds a production site and they are routing all of the hydrocarbon liquids, including the produced water, through pipelines off-site, rather than storing any liquids in a tank. That would then require, in some instances, combustion of any emissions associated with that tank, and also trucking of the liquids from the site elsewhere. So having a production facility where the operator is piping all of their fluids off location reduces emissions significantly at the site, because storage tanks are one of the primary sources of emissions. And so you just reduce that right away. You also reduce truck traffic, which is another significant source of emissions. And it's just a very good practice, and is what most of the operators are now doing. They're designing their facilities in the Denver metro area to be tankless facilities.
Okay. Thank you for that.
And I guess I would just add on the reduced emission completion piece. So I mentioned that the EPA rules do allow for exceptions to capture based on economic or technical infeasibility. The COGCC rules that were just adopted last week, and the county participated as a party in that rulemaking. Those rules actually close that gap even further. So now there is no just straight infeasibility exception that an operator could utilize to combust rather than capture gas during completions. They have to now go to the COGCC and request permission to flare during completions, and then they have to make a demonstration as to why capture is infeasible in a particular instance. So the COGCC has just narrowed essentially the exception for flaring under the EPA rule.
Okay, we took that little segue from 12700, which was the seismic testing. Are there any other questions on seismic testing before we move on?
Not a question, but there's one, I just caught a typo. Hopefully I can find it quickly. Hold on here. Come back. It's not anything we need to discuss. I'll find it before the end of the meeting there.
Okay. Thanks, Kevin. All right, so 12800 is the application process. What questions do we have on that topic? This is Commissioner Libby. I have a question on the notice section, section H, and specifically H1B and 1D. So this relates to who gets notice of an application. On B, it says to the owners and lessees of the parcels of land. I'm not aware whether lessees is public record, and I don't know where they would get that information. So is that feasible for an applicant to have that information?
I think the way that works is that they send the notice to the physical address. So the owner is going to be on record and with an address, which may or may not be the same as the property they own. And then if it's different, then they just send it to occupant at, you know, the address of the actual parcel. So I think that's how that gets covered. Is that right, Kim?
Well, that gets at the tenant versus owner situation, but I think what Commissioner Libby is speaking to is the HB, correct? The owners and
That's
lessees of the parcels. And that's a good question. I think we will have to look into how a lessee would be identified. I'm not sure if that comes up in the title work. We are requiring that title work be completed. So I think that it comes up in there, but we can confirm.
Yeah, it seems to me there's maybe enough between A, B, and C to combine somehow into two of them and cover the owner's physical and mailing addresses, parts of that. And then related to the water source owners, the question about that was, I guess, what does water source owners mean? And is that intended to be the ditch company or shareholders of a ditch or waterway? How does that work?
I think one of the portions of that, I'm going to run down to the definition section. One portion is domestic well owners, and that is a matter that's housed, that information's housed with the state water Division of Water Resources. Yeah, so if you look at the definition of water source at the end, it's water bodies that supply domestic, agricultural, or municipal uses. So that would include ditch companies, for example, or water wells registered with the Colorado Division of Water Resources, and that's where that information could be found. And then municipal, public, or commercial wells and monitoring wells.
Okay.
So there's a variety of things, and that it may be that they have to be looking at a few different sources of information for that.
I think this is just an evolution and strengthening of our regulations from the 2017 version. So I think the 2017 version only referenced water well owners, and we're trying to be more expansive and include other potential water source owners in this list.
And I'll add that one of I think the industry parties made a comment about how are they supposed to figure out who the water source owners are. So that's something we're going to have to look at, given the breadth of our definition. We'll have to look at that to make sure that it's a doable thing.
Yep. Okay. Thanks.
This is Commissioner Gargano. So in this, we talk about notifying people within a mile. And I just thought I'd bring up, a lot of people kept in, especially the written comments were referencing, I think it's a mile and a half, 8,000, maybe more than a mile and a half, 8,200 feet or something like that. So I just had a question about the mile versus the 8,000 feet-ish.
So a mile is an increase from the 2017 regulations. I think we had a half mile in those. I think we felt a mile was adequate. I think it's open for discussion from the Planning Commission.
I couldn't quite tell where the larger number that others were referencing, and I think they were also referencing that number as like a potential distance from just that we shouldn't build, but it just felt like a number that maybe we should consider for notification.
That's what I remembered. It was a potential setback number that coming from a particular study. And it was 8,000 or 8,500 or something. So that's, a mile and a half. So yeah, that number is up for your discussion if you'd like.
Thanks.
One thing that I will add just about notice in general is this section is pertaining to the direct notice that would be mailed to the folks that are listed in this section. I have no doubt that there will be plenty of publicity around any application that is to be submitted to Boulder County, including, signage on the site itself, posting on our oil and gas website, emails to the folks that have signed up on our listserv, interested parties. So to the extent that that helps cover people beyond the mile direct notice area, I think there will be a lot of public advertising of any application that comes in.
Anything further on applications? Okay, 12.
This is Commissioner McMillan. I did find that typo, so I'll go over that real quick. It's in section back to 12700 quickly. 12700 C11AI4. The phrase just ends submitting a detailed, and then there's a period. I think what you want to add there is plan of action, or I'm not exactly sure what the detailed item is. I think that's what you intend. And if it is, I think that's a good change. Putting in the words plan of action. C11A14, which is why I was having trouble finding it. It's kind of buried in there.
Okay, thanks, Kevin.
Thank you. Wow, those are some eagle eyes to realize that sentence was unfinished. Thank you.
All right, so section 12900 is the application submittal requirements. Any questions on this topic? This is Commissioner Libby. I had two areas of comment under section B around the various maps and documents that are being submitted for the site in the area. The surrounding land use one, I think, I guess the question there is, are you asking the applicant to determine the land use, or is that just a map of existing land use provided by the county? I'm not sure what we gain by having them assess the land use or identify it. And then on the wildlife one on 13, I guess I just felt like this was kind of openly defined. It's not asking for a wildlife study of some kind, but it is asking for pretty detailed information about population numbers and species. And I know those have some interest to the public. So if you could maybe just talk a little more about the wildlife determination and how that came about.
Sure, I'll start with the surrounding land uses. Land uses is sort of a generic term there. It's really what kinds of development is in the area. Are we talking about single family residences? Are there other industrial uses? Are there other oil and gas facilities in the area? Is there, a tree nursery nearby? What types of things, for lack of a better word, are in the area that could potentially be impacted. And I think this goes to the question that Commissioner Fitch raised earlier. It will help with our evaluation of cumulative impacts and how an oil and gas facility contributes to the general area.
Okay, maybe just some more guidance of how to submit that. I don't think it's clear from the description what you're looking for, which what you just said was very clear, but that's not what's in the text.
That's great direction. Thank you. And then as far as the wildlife one, I think what we're trying to do here is really just get an inventory of the types of species that might be present in the area so that we know that the applicant has identified what they need to be aware of, and that we have that baseline information when we look at any impacts that might occur to those wildlife. Does that make sense? I'm not sure if I answered your question.
Yeah, it does. It seems like it could be something relatively cursory or something very, very detailed. I guess the natural resources planner would help in assessing that, whether that's enough of an application, enough detail for the application, basically.
I think there's some preliminary information that gets submitted with the application. So they would look at our comprehensive plan maps, and then also wildlife that's identified by Colorado Parks and Wildlife as a start. And then when we conduct the actual review, and we have referral agencies like our natural resources planner and our Parks and Open Space Department weighing in on that, on the proposal, we dig much deeper into the specifics, and they would just be flagging what's on site for us to dig deeper into.
Yeah, I guess that's kind of what I wanted to get to is D5 later on requests an independent expert's report on impacts to wildlife. It seems like that's kind of bleeding into the earlier request in the application. The first one, if it's just saying what is already available from the county and the state, makes sense to me. That's easy to pull together and identify. Then asking in follow-up for the more detailed one makes sense. It seems to me like the text in the first one is asking for quite a bit of detail and duplicating that in D5.
I think I see where you're going with that, and I agree that we could change the wording in B14 so that it is a simpler statement, and then the expert report would look at both what's there on a more granular kind of level as well as the impacts. Is that what you're?
Yeah, exactly.
That makes sense to me. I agree.
And I think D5 in general is just to recognize that we may not have internally on county staff the expertise to really provide the analysis that is necessary to look at impacts on a particular resource, including wildlife. So there may need to be an outside consultant that is hired to provide that information to us.
Yeah, I understand that. I guess in D, so D says something about basically saying any independent experts must be approved by the county and retained by the applicant, which makes sense. But the subsections of D are not saying you're requiring all of these different independent reports. It's saying that if they are required, this is what describes them. So, D1 through whatever, all the different pieces, are those all required reports, or are they describing what you would require if you ask for them?
They're what we would require if we ask for them. So I think D is written, what it's intended to do is also say that potentially a requirement could be any independent expert, engineer, or consultant's report, such as the following that are listed.
Okay, if it says that, that would be good. It doesn't say that, but that would make more sense, yep.
Yeah, I agree. There's some clarification needed on that intro sentence. I think our intention was to require all of these in the list, and what we meant was wherever there's reference below to an independent expert or engineer consultant, that person must be retained by et cetera, but that the reports themselves, anyway, we'll make sure that that's clarified.
Thank you.
Yep.
Commissioner McMillan, question about insurance. Find my section here, 5J, contractors. It says that the operator shall require adequate insurance of its contractors and subcontractors. And all the sections above, I think all the insurance requirements are great. I think I'm trying to assess how this could come into play. And my first question is, what's adequate and how do we limit the county's liability in this case, where I don't know exactly, but it's likely that you would perhaps have a separate contractor who's actually doing a lot of the construction, who's separate from the operator and of the well, and something that they might do might lead to something awful happening. And so I think that having them insured is actually a really important thing. And we have a pretty meaty sentence here that says, the operator agrees that it shall be responsible for any damage or loss suffered by the county as a result of negligence by the operator or any subcontractor. So I guess I have sort of a two-part question here. One is, what's adequate insurance for a contractor outside of the operator? We go to great lengths to say what the operator's requirements are, and I think that's great. But how do we verify that the folks that they are hiring to do this work are going to also be insured in the event that something awful happens and we're calling on their insurance to cover a disaster of some sort, where the operator, may feel that, the liability really lies with the subcontractor in that case. And so my question, I guess, is there a way for us to further verify that, or further require, or have the operator sign an affidavit, or some way to verify that they are requiring insurance of all their contractors? And have you all thought about that in greater depth than perhaps just this sentence here?
So my comment on this is that the second sentence is, from the county's point of view, takes care of the whole issue, because what basically what this is referring to is there's a chain of contracts, correct? And so there's the operator, and then they have a contract with their drilling company, and in that contract they get to what we call allocate the risk between them however they see fit. So normally the operator would build in provisions in there that where the driller, the subcontractor, takes a certain amount of the risk on himself, et cetera, et cetera. And they get that all squared away however they want to do it. we, as the county, don't want to deal with that. We don't want to chase the subcontractor or the subcontractor or anybody else. So what we're saying is we look to the operator for absolutely everything, no matter whose fault it is. And then if they want to protect themselves from that, they can deal with that in their contracts with their contractors and subcontractors to protect themselves. We are going to look to them only. Does that make sense?
It does, yeah. And I think that's the way it should work. But what happens if you look to them and then they look to their subcontractor and they weren't insured appropriately?
So the operator, I mean, to way oversimplify, but the operator pays us, and then they go to look to their contractor, and if they can't get paid recouped from their contractor, that's their problem.
Yeah.
But we're made whole.
Right. Okay.
That, you know, the adequate insurance, it's whenever you have that word, it always leaves that door open. So we will take a look at this. This language did come from our risk management department, who are experts in this stuff. So I just, you know, that was about the limit of everything I understand that I just poured out there. So we can double check if there's any lack of clarity there. But I think the second sentence I feel very confident in. The first one I can understand how it does kind of open a question.
Yeah, I think it's really important, you know, and especially if you were to get into it, you know, something terrible happening.
Sure.
And maybe what I would suggest is maybe that there's some sort of affidavit that the operator can sign to say, you know, this is the insurance that we expect and we'll have all of our contractors carry. I don't know if that's absolutely necessary. I just think it's really important to get this section really, really bomb-proof for protecting the county.
Okay.
And that exact language actually occurs somewhere else too. I think it's in 12700 with the.
Yeah, we use the same language. So it would, yep.
That's all. Thank you.
Okay.
Commissioner Libby, I had one other suggestion or comment, which is C.14. So section C is the proposed development information. So the contents of the application, basically. C14 refers to worker training and records, which I think is an important topic, but I don't see anything in the language that is actually asking them to submit anything in the application about this. It's just saying basically that all workers shall have any applicable certifications, and if requested, they should supply it. So if you'd like it to be supplied with the application, I think we should say that here. The language to me doesn't seem to imply that you're asking for anything specific, or it could be moved out to a different heading or section about training that's great information as guidance, but I don't see what it's asking them to submit here in the application.
I see what you're saying. Okay. Mm-hmm.
Any other questions or comments on 900 submittals? Okay, 12-1000 is the special review standards.
So this is Commissioner Fitch. I don't know whether you could, it's possible to bold that section, which is a paragraph that starts off with 12-100 special review standards. And then there are two paragraphs that specifically talk about if there are conflicts between what you would say meeting condition 14, but not meeting condition 16. Because if there's some way to bold that, particularly to emphasize the second paragraph, which says it's not just trading off a benefit in one criteria versus a cost in a different criteria. Because it struck me that a couple of people in the public hearing yesterday were paying attention to the first paragraph and worrying about that, and they weren't reading the second paragraph.
Hmm.
I think we can look at whether it makes sense to rephrase it in a way that calls better attention to the second paragraph, or whether there are other formatting techniques such as bolding, like you suggest, that would help call that out. But certainly in our communication around it, we can try to clarify how we intend to utilize these standards and make decisions.
Thank you.
Yeah, that's a good point. I like that.
Nothing further? Okay, 1100 is conditions of approval. And just, I guess, one question for staff. So these are basically examples of conditions that might be included, but not the only conditions that could be included. Right, okay.
This is Commissioner Gargano. So clarifying, this is that area that sort of says we have a setback of 2,000, but looking at location, section A, for instance, we may need to make adjustments. And so this is that part where, yes, it's 2,000 to be in accordance with the state, but this could mean that there are other circumstances and that changes.
Correct. So it has to be 2,000 feet at a minimum, but we may be shifting and requiring further distances or, moving depending on what might be impacted or interfered pursuant to the standards.
And then B being more about that, since these are bigger and bigger wells, and that means more noise and more potential pollution or disruption, et cetera. This is where we are given that leeway specific.
Yeah, on a site specific, under a site specific analysis. So is the particular scope and magnitude of the particular proposal excessive for the parcel that it's on, or does it work for the impacts that are on that property?
Yeah, because I think no one brought it up exactly in this way, but talking about some of the larger proposals and if we, why we wouldn't necessarily say only of a certain size versus using this instead to say on a site basis we make that decision.
I think it's again important to recognize that there's such variability that we have in unincorporated Boulder County, even in the eastern area where the Wattenberg lies. We have various sized parcels. There's just too many different factors and differences between sites that we can't account for super specifically in these regulations. So we had to design the regulations to allow for us to make those site specific evaluations.
Thank you.
This is Commissioner Bloomfield. Is it fair to say that like on the scope aspect that you would have, a third party reviewer with expertise in this sort of thing that would evaluate, if the number of wells was appropriate? And I guess there's the question of
Have trouble hearing Mark, right?
I don't know if I want to even get into this, but the question of, oh, is my internet?
Yeah, maybe just stop your video, Mark. We got most of that, but go ahead.
All right. Just the question of, I guess I'll just leave it at the question of whether you would have an outside expert that would be looking at the total number of wells and their appropriateness and whatnot.
So you're talking about, I'm sorry, let me just run back up here to section A, and if we were making those kinds of adjustments.
Well, and section B also, the
oh, gotcha. Yeah, right.
Into the reduction or limitations on the number of total wells.
I think throughout the regulations, we have the ability to hire whatever professional expertise we need. There's obviously a great deal of information here in a lot of separate kinds of areas of expertise. So if we needed that kind of expertise, we absolutely would. I don't know that I could say that we could say here that we always would need that, but if it appeared that we did, we could do that.
Yeah, and I think we've talked about that a little bit internally of, do we need to ask, is this many wells necessary to drain the minerals that you've indicated you have the rights to? So I think there's those sorts of questions where we may need to get technical expertise, but there's also sort of a staff level analysis of, is the, are the dimensions of the disturbed area reasonable for that particular parcel on which it's proposed. So I think there are probably different levels of inquiry that go into looking at that particular question.
Makes sense. Thanks.
Are there questions on conditions? Okay, scrolling to get to the next section. Through GG, there's a lot of conditions there. 12-200 is judicial review. I don't have any questions on here. I guess I would ask Kate if you can just speak to what this means.
This is simply reciting the state law that whenever the county makes a final legal determination, it's reviewable in court. So that's the case whether we say so or not. It's just reciting that and making it plain. So it doesn't add anything or change the state of things.
Okay. Any other questions on that? Okay, 12-1300 is the procedures following the approval of a special review application. Commissioner Libby, I had a question on C.1 in this section about commencement of operations. I didn't see, I guess I should check. I was pretty sure operations was not defined in the end of the document. Does that basically mean commencement of development or commencement of actual extraction after development is complete in terms of what has to happen within 2 years?
I think that's a good question. We do have oil and gas operations defined, but not operations by itself. And that, yes, it could mean moving the first shovelful of dirt or, yeah, pumping the first barrel of oil. So I guess we need to internally clarify that. I don't know. I don't think we've discussed that.
Okay. And then
Thanks
another,
for pointing that out.
Yeah, another question on 2 in that same section. So after 10 years, 10 years after the approval by the board, the applicant can reapply for an extension. Is that renewal the same process as is defined in the rest of this article? There's no different process, right? So it's the same kind of submission, application, information. Is that the intent? Okay.
Yes. And then just going back to that question about operation, I think you're right to point that out, and we can clarify. Typically what we do in other contexts is we track that from the time that they submit their actual permit. So there will be a permit that follows an approval if there is to be one of an oil and gas facility, and then it would be 2 years from that date. But those are certainly clarifications we can make in here.
Yep, sounds good. Thanks.
One thing I just want to point out to you in 12-1300E, we get a lot of requests from operators about repairs or maintenance work that they need to do to existing oil and gas facilities. Our intent is to learn what some of those typical repairs and maintenance activities are so that we can develop a list of ones that we perhaps don't need to review. So some of them are pretty innocuous and, you know, just take a pickup truck and 2 guys going out there to kind of do the repair that they're doing. We've been asking for oversight on all of those. 1, so we can be aware of them if we get questions from the public. 2, so we can gain a better understanding and really it's our own edification of what those activities may include. But we'd like to get to a point where perhaps some of those don't need our full analysis for those. Jasmine's been handling a lot of those, so I just want to give a nod to her for the review and the coordination with other departments on looking at those activities. And hopefully we can get there. We're starting to get a better understanding of that stuff.
Commissioner Libby, I guess I'm a little bit concerned about that, so thanks for bringing that up, Kim. Is there a way that this can be, because the way it's going into the code right now basically says that any repair or maintenance has to be submitted within 24 hours in advance or as soon as thereafter to the director. If you at some point decide, oh, well, when they go and change this gas fitting, that's standard enough, we don't need to see that, that would now require a land use code amendment, I think, to reflect that in this, right?
It would not. So what this allows for is the director to maintain a list of routine maintenance activities that the operator could undertake without county review or approval. It's the very last sentence.
Oh, okay. I didn't get that far. Okay,
yep.
Great.
Yeah.
Because otherwise I would think there's
exactly
a lot of
right.
things happening,
yeah.
right? Yeah.
So yes, that's exactly right. So, you know, we know that they do some things on a monthly basis. There are other things they do on a quarterly basis. Right now, it's been helpful to learn all of those things so that we just gain a better understanding of how the whole operation works. And we've been able to coordinate with the existing operators in the county. But not everything requires our oversight. Some things have been helpful, so we could have wildlife timing, or, you know, we work with, there may be an agricultural landowner who needs to irrigate at the same time, and so we need to work around his schedule. So things like that, it has been helpful to have some oversight, but certainly not everything needs our input.
Hearing no other comments, we'll move on to 12-1400 inspections and enforcement.
So it's Commissioner McMillan in the penalty calculation. You've got the director has discretion to assess a civil penalty between $300 and $15,000 per violation per day. And I understand that range is based on, there's a lot of different violations that could occur, and there are separate fines out there for those violations. Is there a real value in having the range there? And the reason I say this is because I assume fines change annually. if, for all these different things. And I wonder if just saying something like, at the, currently stated levels would allow some latitude, because I don't know, maybe there's a certain fund that goes up to $50,000 per year. I don't know what it would be. And then you've got a land use code that's in conflict with that. Put it out there for discussion, but are we sort of hamstringing ourselves in the future if things change is my question.
And Gavin, you're referring to 212-1500, the fines and penalties? I think it's one section ahead of where we are.
Oh, did I move on? I'm sorry. Yes, I am.
We can talk about that if there are no other comments about the inspections and enforcement.
Oh, my apologies.
I do have a question on inspections and enforcement. So when we were previously up in the category for pre-existing facilities, there were some requirements for self-inspection and reporting. Unless I'm missing something, here we're intending for those to just be defined through condition. Is that true?
I'll jump into that. I believe that, yes, so for new development, there are inspection and monitoring requirements all through the conditions of approval section. And so the operator still has a significant responsibility to be monitoring and inspecting and reporting, but instead of being in one place, it's under the air section and under the water section, and it's sort of sprinkled throughout the conditions of approval. So then this section for the county's right to inspect is then additional to those requirements that are in the, what is it, 1100, I think.
Okay, but those conditions listed are potential conditions. I guess the question is, are there any things that we want to always be in place that should be listed here in inspections, that are not appropriate to necessarily be just conditions because we would always want that particular thing to be inspected and or always want it to be inspected by a certain party and not be something that's part of a condition. It's like a baseline inspection statement that should always be in place.
So I think that's up for you to probably discuss. The reason I'm kind of hesitating is it gets into the reason that the conditions section is written as potential and not required in each and every instance is, again, it's similar to what we've talked about before. It's to maximize the county's discretion based on the site-specific, fact-specific circumstances. That's never, and throughout the code, that does not, should not suggest or indicate that we will ever have no conditions of approval or just, a very cursory look. That's not at all why they're written in that way. So I think that I think I hear the point you're making for this 12-1400 section. I think that's a fine idea if that's what this commission wants to recommend. I think that we can safely say that no approval will go through without significant conditions that include inspection and monitoring. However, if it, that's up for your discretion if you feel like it needs another statement.
Yeah, I believe that that's true, that there will always be, significant conditions in place. I just wonder if there are there's a certain baseline that must always be in place that we could move to this inspection section.
Yeah, I think that's wholly in your, this group's discretion to discuss and come up with a recommendation.
Okay. So that's, I guess, once we reach the discussion phase, or are we discussing as we go, or should we discuss that
I
now?
would say we have been discussing as we go.
Okay.
So maybe while it's top of mind, let's just talk about that for a few minutes, and you can maybe restate what you suggest, Dan, and we can then respond.
Okay, yeah. So I guess one of the things that I was expecting to see in this section was something matching what was in place for pre-existing operators, pre-existing facilities. So including the provision that the operator should be self-inspecting and reporting monthly. I was expecting to see a minimum of that. Obviously, the conditions could go further than that if it warrants, but I couldn't imagine a scenario where we wouldn't be conditioning monthly self-inspection with essentially the same language we had in the pre-existing facilities.
This is Commissioner Gargano. I just wonder if by making it always a condition, to Kate's point, would that mean that we are making it harder to change the condition, right? Because then you have that one, but then you're also trying to alter it, but it's always a condition. I'm just wondering if we're adding unnecessary complexity, I guess.
I agree it's missing, Dan. I guess I would propose adding it to the list of potential conditions of approval as a more explicit thing. I think this section's intended to be more about provisions for inspections and enforcement, not the contents of the inspections and enforcement. So like the provisions being, there's a right to enter, here's how we handle records, what happens with violations, et cetera. It's like a container around those. Whereas I agree the self-inspection does seem to be missing from the potential conditions and would probably be applied, but maybe it's more suitable to that upper section.
I'll also point out that this 12-1400 is the county's rights and powers as opposed to what's being imposed on the operator. So it may be more suitable. Yep.
Yeah, and I like that because that solves my concern, I guess.
Okay. So basically an addition into the potential list of conditions. It was more explicitly matching what we had also listed for pre-existing facilities.
Yes, that's what I'd suggest.
Okay, makes sense.
Okay, any other questions or comments on that topic or on 12-1400 in general, inspections and enforcement?
Let's see here. I might have one more. Is there language relating to the cost of inspection? So if the county has the right to enter and do whatever types of inspections that it wants, are there costs associated with that, and are those costs intended to be passed on to the operator? So we talk about fines and penalties. This would be, I guess, more about like a compliance cost. So suppose they had a violation in the past, maybe we're doing more inspection after that to confirm that everything has been fixed. Is there any language related to recouping costs related to our inspections and enforcement of remedies?
I'll take a shot at answering that. I appreciate the question. I think there's nothing in the code that talks directly to recouping the costs, but what we've tried to do is account for the anticipated time that we may end up spending on inspections in the application fee. that ultimately gets adopted. So when we adopt fees, which is outside of adopting the regulations, we'll have to see, you know, who all is involved in the review of this, you know, the hours that go into it, that sort of thing. And then that gets captured in the amount for the application.
Okay.
And I'll add too that I think you were, the last part of what you were saying is specifically talking about additional inspections if they've been violating or had some sort of problem, as opposed to normal routine inspections. Is that correct?
Right. Like what if there was, yeah, exactly, some type of issue that we have to then verify has been fixed, maybe more on more than one occasion.
And I think that that might be worthy of adding, for example, in section F, increased inspection frequency, you know, at the operator's cost or something to that point, because it's not the normal expected inspection will be caught, like Kim was saying, but anything additional, we may want to add something. I think that's a good point.
Because, yeah, I remember in our conversations last time these regs were in front of us, there was a discussion about, you know, methane leaks, and that if there had been a violation, the county potentially would want to confirm on more than one occasion that the methane leak had been fixed, and that there was a cost associated with that for the county to do that activity.
I think that's a good point. And, you know, whether it's captured in the regulations themselves or as a severed part of a fee schedule that has, you know, fines and penalties and those costs, the dollar amounts defined outside of the regulations, we can address it in one or the other.
Okay.
This is Commissioner Gargano. It sounds like there's two parts. Like Kate was saying, we should say it'll increase, or, you know, additional would be at their expense, and then what that actually costs would be in the fee schedule.
Right. Yep.
Right. So maybe as far as this code goes, in F, we add a new item that just references that the county has the power to recoup costs associated with additional inspection and enforcement.
Yeah, that's a good idea.
Yeah, I think we're talking.
Noted.
Okay, thank you.
Thanks, Dan. We're ready to move on to what should be labeled 12-1500, fines and penalties. And Gavin, I'm sorry for cutting you off earlier. You probably have to restate your comment here about the range of dollar amounts, I think, right?
Yeah, my apologies for getting ahead. Yeah, just to boil it down, is there really a reason to have the range in there? And by having it there, are we hamstringing ourselves in the future if there are fines that are greater than $15,000? That's, I think, the range of what we expect today, but I assume those things could change.
I think that's a good point. And the reason that the range, let me just say the range exists and is as large as it is because there are such a variety of different statutory rules governing what we can fine people for various different things. So there's rules around air emissions specifically, or around certain other kinds of code violations. So in each case, we have to be checking against the statute. So whether it helps or hinders to actually have numbers there as opposed to a more general statement is something that we could discuss. I'm sure there's some probably legal considerations about that and the implications of that we would need to look at. And if you wanted to talk about it further, maybe in executive session. But it's a good point that we can certainly discuss internally, and then we can let you know whether we need some executive session time or have come up with a simple solution. And I don't know if any of my county attorney colleagues want to say more about that.
Yes, this is David Hughes. I would agree that there are some potential legal considerations for leaving an open-ended fine structure, and that would be something that if you wanted to go in detail about that, would probably be better discussed in executive session.
Okay. I think it's fine to have them in there. I wonder if a qualifier of just or as adjusted from time to time or something like that. And if we need to discuss that in executive session, I completely understand. I think it's okay as it is right now. Just wanted to air the question. Thank you.
Okay.
I have a follow on this, Commissioner Libby. Just if you could explain, I assume there are also other bodies that can levy fines for violations besides the county. So these would not be the only fines for some kind of violation potentially, like COGCC can do that as well.
Well, these would be, so these are for violations of our code.
Right.
If the same violation also violated COGCC's rules, then yes, they could, but they're two separate. They can't fine for a violation of our rules and vice versa.
Right.
But there might be an overlap, yes.
I think, Gavin, speaking to your point, if something really bad happens, there's going to be more than just the county fines that are limited to that amount. Like it's not the only limiting factor. That's my reading, at least. Any other fines and penalties comment? Okay, our last section is on definitions. Any questions or comments here? Okay, did not expect any. So thank you all for running through that.
Commissioner Libby, if I could just interject, I want to make sure that you don't have any comments or questions about the other provisions in the land use code that are also proposed to be amended. That's the section that follows definitions.
Yeah,
it's snuck
with
right
the red
in there.
lines. Yeah, the red lines and the additions. Yeah.
And we did propose one modification to that yesterday in our recommendation.
Yeah, can you remind us of that? I recall it being minor, but I don't recall what it was.
It is. It's striking the entire section of 7904D. So eliminating D in entirety.
So any comments or questions about the other provisions, which are basically adjustments to other parts of the land use code that reflect the new text here, as I understand it, or refer to this new text?
This is Commissioner McMillan. On 4514E, we added gas and or hazardous liquid pipelines not subject to Article 12. What type of thing would not be subject to Article 12? What is this written for?
Well, that's a good question. We're not sure exactly, but we didn't want to accidentally leave us powerless to regulate things that might. So for example, a natural gas delivery line from the utility company to the house would not come under Article 12. That's one example I can think of, and there may be others. So we just wanted to make sure that there was a vehicle still to regulate things, even if we couldn't quite imagine what they were at the moment. But that's one. That's one.
Basically, we retreated to the language that was there before we started amending it with the 2017 regulations. So it's a section of code that was in the land use code prior to the 2017 changes.
Sort of a fallback language if you need it. Okay, thank you.
Can you, I have a question about the last one, Article 18-124C, COGCC. Is that just adding a definition and a description of that organization as a referring party, or what's the purpose of that text?
Correct. We refer to COGCC in some overlapping provisions, I believe, in the code. And so it's just spelling out who they are.
Okay, cool. Anything further on the additional provision changes in land use code? Okay, I think our last order is to discuss, any further questions can be asked certainly, but to discuss overall perspectives and feedback on the proposed changes, and then whether we're comfortable making a recommendation to the commissioners or looking for more information in a follow-up meeting, and where we're at on that. It'd be good, I'd like to ask every commissioner just to give some perspective on their thoughts on this, if you don't mind.
Commissioner Libby, can I interrupt for a sec? Can
yeah,
I
of course.
ask for just a very short break?
Oh, fair enough. It's only been 2.5 hours.
I could really use that.
Yes, yes. Let's take a 5-minute break until 6:35 and reconvene. Is that okay? Great. Great. Thanks for the reminder, Kate. Appreciate it. Okay, so I think we have an opportunity for discussion, and of course, any further questions that come up. Moving towards a recommendation to either pass these forward with all the suggestions we've made today, ask for any significant changes to be brought back to us in a future meeting, which I think would be a week from today if we ask for that, or not recommend passing forward. Those are the options.
Commissioner Bloomfield. I want to thank staff for the enormous amount of work that went into this. And I feel like this is, you know, for my mind, it's the best that we can do given the powers that we have as a county. And I like the fact that that there's some flexibility. And, you know, I imagine that this is going to be a continually evolving thing, both in terms of, you know, what we learn as this goes forward, and then also how things might change at a state level. I feel like this is a really good start and a really good floor, if you will. And then, you know, my hope is that we can gather more knowledge and take steps in the future. Again, if this is the floor, take steps in the future to make sure that we're really safeguarding the, you know, the health of county residents, the environment, wildlife, all that stuff. So I would be comfortable moving forward with a recommendation to approve it.
This is Commissioner Gargano. I want to echo what Mark said. I really appreciate staff's work on this, and I know we all wish that the county had more authority than it does, but given the authority that we do have, I really feel that this protects us, gives us the flexibility we need to make the right decisions on a case-by-case basis for our county and based on locations. I don't think we've made any major changes or requests today that would need to come back to us. I think it's really all addressing kind of what we heard from the public and the questions that we had, and I'd be comfortable with those changes just being made and brought to the county commissioners.
This is Commissioner Fitch. I would echo what Lishan and Mark have said. I think there are lots of complexities here. I trust the staff has evaluated not only the science and what do we know about the impacts, but also what we don't know yet. I do hope we will continue to reevaluate these regulations at regular intervals. But I don't think it has to come back before the commission. I'm happy to support a motion to forward it to the commissioners.
This is Commissioner Neske, and I would say the same as well. I really appreciate staff being really on the forefront of this and being really aggressive in making sure that our regulations are as stringent as we can be, as we're allowed, and just also updating us and the transparency for the public with the oil and gas website, and making sure that everyone has as much knowledge as possible on this as we move forward for the county. And I really appreciate the thoroughness that we have with these regulations to make sure that we're protecting the people and the environment as best as we can. So I say thank you very much, and I would support it as well.
Commissioner McMillan, I support moving this forward to the commissioners with the edits that we made today and the additional direction to staff. And I'll repeat it again because it's definitely worth repeating. You all have done an amazing job synthesizing a great deal of information into code, and it's impressive. I think it'll be used well, and it gives us a good framework for reviewing any requests that would come forward in front of us, and gives the county flexibility to address things that we may not even anticipate as of yet. And so kudos to all of you, and I support moving it forward. Thank you.
This is Commissioner Hilton. I'm supportive as well. I have noted some of the modifications that we have discussed. So if we want to try to articulate those at the end, I can list some of those, or if we want to instead rely on the video record, that's fine as well.
Yeah, Commissioner Libby, I was just going to say, I think there's a number of things where staff said they would basically look into things and eventually make changes. Most of those I think were minor wording or clarification or changes to numbers, like a number of days potentially. I'm pretty comfortable with them making those changes in the submission to the commissioners. It'd be good to have a overview in the next draft of what was changed. I assume you would do. But I think we can either rely on the record, or if there's any that you want to revisit, Dan, that's fine. To me, the next big thing is if and when an application comes in, that's a whole nother challenging set of discussions and notifications and topics. But this is a fantastic foundation for reviewing and guiding an applicant through that process.
Does staff feel that they need clarification on any of the changes that we've discussed, or do the commissioners feel that we need to kind of reiterate any changes that are significant and make sure those are clear?
This is Commissioner Gargano. I think we were pretty, especially on the ones where we felt like we needed to be specific. I think the record, it's pretty clear that we were, and other places where they need to look up. I mean, if you guys are okay going back through this video again, because I know you want to watch it again.
I think this is Kim Sanchez, Deputy Director of Community Planning and Permitting. I think we took prolific notes throughout, and amongst the entire team that has been part of this public meeting, we can put our heads together. Certainly not opposed to you running through a list of things that you jotted down, Commissioner Hilton, if you care to do that at the end. It doesn't hurt to do that.
Sure, I could do that. One thing actually that I don't know if we did nail down, or I had a potential modification for that maybe we didn't discuss, was increasing the notice area.
Yes.
So this is 12800 H1A. Do the commissioners feel that we should direct staff to increase the 1 mile radius notice area?
Commissioner Libby, what I was going to ask when that came up before was how that relates to other notices for other special use or other land use dockets. I always like to align to existing notices or standards if we could. I don't remember what that is now. It's either a mile or a mile and a half, or it varies by the type of docket, I think.
Well, this Commissioner Gargano, as the one who brought it up, when Kim mentioned that that's not the only way people are going to get notified and that these are going to be really public things. So in her response there, I personally felt like dropping it because I agree. I think it's going to be a pretty public thing and a lot of people are going to get notified in different ways. I'm not against making it a mile and a half, but I'm not sure that it's necessary.
This is Commissioner McMillan. I asked the question of staff, but in my experience, it's typically like a 500-foot buffer from a property. I think a mile exceeds more than any notice I've heard at the county. Is that true or?
Yeah, this is Kim Sanchez. I think for many of our applications, the area of notice is 1,500 feet from the property lines. So this is certainly more expansive, but it's also justified by it being a far more impacting type of proposal than those that we typically see.
Oh yeah, Commissioner Gargano again, I don't think it should be less than a mile. I just am not strongly opinionated that being more than a mile.
Okay, so I can list the other modifications that I have noted, and I'm fine to leave that increased notice area if the rest of the commissioners are okay with a mile. So the other things that I have noted are clarification of who water owners are in 12-800-H-1-D. There's a typo in 12-1100A14. Clarification on operational commencement dates in 12-1300C1. In 12-1100, adding language to come up to the minimum inspection and monitoring language to match what's required of pre-existing operators. And then in 12-1400 F6, adding a new item that the county may recoup its costs associated with inspection or enforcement from operators. And I think there were other items, but those are just what I had captured.
Okay, I'm ready to make a motion if you guys are good with that.
Yes.
Okay.
Yes.
I move that the Planning Commission approve and recommend approval of docket DC-19-0002 to the Board of County Commissioners.
Second.
Okay, we'll take a roll call. I'll do it from the video. Sam Fitch.
Sorry, Commissioner Libby, and that's just to clarify, that's with the changes that you have recommended that we look into.
Yes.
Yes, that's right. Yep. Should I re-motion that, Kim? Is that okay?
I think we got it. Thank you.
Okay. Yep. All right. So that's a roll call starting with Commissioner Fitch.
Yes.
Commissioner Libby, aye. Commissioner Gargano.
Aye.
Commissioner Hilton.
Aye.
Commissioner McMillan.
Aye.
Commissioner Neske.
Aye.
And Commissioner Bloomfield.
Aye.
I think Commissioner Quigley left at some point, so that's all ayes and the motion passes.
Thank you.
That's all of our business for today. So we're going to close the meeting and thank you all for your time tonight. And we'll see you in a few weeks.
And we return the thanks back to you. So appreciate all of your time and review in this issue.
And thank you to the public for attending and listening as well. 7 of you lasted as long as we did. We appreciate your attendance. Thank you. Bye.
Thanks, everybody.
Good night.
Thanks.
Thanks, everybody.